board docket number 21 BD 058. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Jack Metzler for disciplinary counsel.
Thank you.
Good afternoon, William Brennan on behalf of the respondent, Mr. Owens. And
Thank
also want my law partners also file our papers as well, Mr. Wall.
Thank you, counsel. Let the record also show that Dr. William Hindle and Sally Blumenthal, who are our two public members, are not in attendance today. Our board rules, Rule 13.6 specifically, allow an absent member to participate in the decision of the board by listening to the recording of the oral argument absent an objection from respondent. Do you object to the participation of the absent board members in this way?
No objection from disciplinary counsel.
No.
Thank you. We are hearing exceptions to the hearing committee report from respondent who will proceed first. Mr. Brennan, you have 20 minutes. Do you want to reserve some of your time for rebuttal?
Yes, I would like to reserve 5 minutes for rebuttal. Please.
Thank you. You may proceed when you're ready.
Thank you. Bring my phone here to keep track of the time. So. May it please the board. As indicated earlier, my name is William Brennan. Mr. Lawler and I represent respondent Joseph Owens, who's present here. I'd like to cover, first of all, the issue of jurisdiction. We filed in our opening brief a motion to dismiss on the grounds of jurisdiction. Now, disciplinary counsel has responded by saying, of course, they have jurisdiction because Mr. Owens is in fact a member of the District of Columbia Bar. We agree, he's a member of the District of Columbia Bar. But the question becomes is, should this board take jurisdiction of this matter and decide this case, or should it refer the matter to the state of Maryland? You set forth some fairly compelling reasons as to why. I'd like to start off with a hypothetical. The hypothetical would be, say a person was a member of the DC Bar, later on moves to the state of Minnesota, has no further contact with Minnesota, commits a few, may or may not have committed some disciplinary infractions in Minnesota. Minnesota chooses not to do anything with it, and then all of a sudden the DC Bar decides, well, we're going to take jurisdiction, discipline a lawyer who has not done anything in the District of Columbia. So factually what occurred here, and the ad hoc hearing committee found that nothing occurred in the District of Columbia. And
Mr. Brennan,
yes,
the rule says that your client is subject to discipline in the District of Columbia. Are you saying that as a matter of discretion, the board?
yes. I'm by no means suggesting that this board does not have jurisdiction. He's a member of the District of Columbia Bar, and of course you have jurisdiction. What I'm saying is that as a matter of discretion, to make a finding that this case should be referred to a Supreme Court of Maryland for disposition, because, as we said in our papers, number one, the retainer agreement that's at issue here was drafted in Maryland. It's a Maryland document, number one. Number two, the IOLTA account where the funds were deposited, and later with the Matthews and Owens law firm where the funds were transferred from the IOLTA account to the operating account. Those are Maryland bank accounts. My client's law office is in the state of Maryland. The respondent resided in the state of New York. And as the ad hoc hearing committee found, not a single event occurred in the District of Columbia. And so when you look at this case, it's what does this retainer agreement mean? There'll be some discussion about that. It's under Maryland law. Where was the IOLTA account?
Do you have a case that supports this contention that the board has exercised this kind of discretion in the past when a lawyer such as your client is subject to the rules? This jurisdiction. Do you have a case where you can show us, or an example where the board or even the Court of Appeals has indicated that such a discussion should be used to refer a case to another jurisdiction?
I've not found a reported case, and I'm guessing, I don't know, it's pure speculation, is that because they get referred, they don't get reported. But that would be my request. And so that then segues immediately, I think, into the choice of law issue. And the disciplinary councils argue that the Virginia law should apply. Oh, I'm sorry.
I have in front of me the retainer, and he says Joseph and Owens Bartlett have been under the past rules. It says also admitted to DC. Why would he put the represent the world, if he's been in District of Columbia. If he didn't intend to obey by professional rules and communicated here, or led by.
Well, he is a member of the. He's clearly a member of the District of Columbia Bar, without a doubt, and I'm not gonna suggest otherwise. And I think I think most rules indicate that if you are a member of another body, you should designate that on your letterhead or whatever. So I mean, I think that's a requirement. So he's fulfilling that requirement. But his office is in Maryland and everything occurred in Maryland in this case. So he designated he's a member of the DC Bar. We're not walking away from that. That's clearly what he is. But my point is that what this board is now being asked to do by disciplinary counsel is to make a judgment as to Mr. Owens's conduct in Maryland. And so the retainer agreement, as we pointed out, was drafted in Maryland. And much has been made at the ad hoc hearing committee and by disciplinary counsel as to what is this retainer agreement? Is it flat fee? Is it hourly? Is it hybrid? We take the position is it really doesn't matter what we call it. What matters most importantly is the operative legal effect. And so the agreement says in the first instance that it's a flat fee case, $4,000. At the request of Mr. Owens's client, Mr. Josselson, a kick-out clause, to use my phrase, not theirs, was put in, and that if Mr. Josselson chooses to discharge Mr. Owens, there will be a refund of any unearned fees at $250 an hour. In essence, once Mr. Owens had performed 16 hours worth of work at $250 an hour, that comes to $4,000, Mr. Josselson would not be entitled to a refund. There's no question. That's what the document says. It says that Mr. Josselson's request, and that was inserted. Now, what we call it, I don't think really makes any difference. It's the operative legal effect. And so what occurred in this particular case is when the funds were received from Mr. Josselson by Mr. Owens' law firm, Matthews and Owens, it was put in the IRS account in Maryland, pursuant to the Maryland agreement. And then at some point in May, at that point, by the way, Mr. Owens was prepared to go forward and try this case in May. It was kicked down further down the road to September, but he's prepared to go forward in May. And at that point, the transfer was made by Mr. Owens' law partner, Ms. Matthews, who transferred the funds from the IRS account to the operating account. So the question becomes, at the time of that transfer, disciplinary counsel is saying that's misappropriation. And we said it is not misappropriation because at that point in time, Mr. Owens had done 16 hours worth of work, which he testified to before the ad hoc hearing committee. He had done 16 hours worth of work. He had earned that money, and no matter what occurred moving down the road, Mr. Josselson would not be entitled to a refund.
So I'm just looking at the retainer agreement. It says client will pay a fee of $4,000. The fee covers all services and expenses of the firm working on the client's behalf. I'm going to skip the next sentence. The firm has the obligation to complete the engagement absent good cause for withdrawal once the fee is paid, right?
That's correct.
So the $4,000, you will agree with me, was to cover the entirety of the matter.
No question about that.
No question about that, right? And there's also no question that in terms of the what you call the kickouts going down, it says refund will consist of original payment minus an appropriate deduction for work performed at the hourly rate of $250 for legal services performed by counsel, et cetera, right?
That's correct.
And in order for that trigger to occur, there has to be a termination by the firm or the client, correct?
That's correct.
Because it says explicitly, in the event that the engagement is terminated by the firm or the client prior to the completion of the engagement, then you would use that hourly fee calculation, right? So we're in agreement so far, right?
So far.
So as I understand it, your client withdrew the funds in May, and then the termination didn't occur until August.
That's right. And
So first, the funds were withdrawn, and it's at that point that you say that he had worked the 16 hours. But the actual trigger that he's relying on in order to withdraw those funds or claim that those funds are his didn't occur after. So how do you reconcile that?
So-
How should he reconcile that?
what I suggest is this, that it was not intentional misappropriation that results in disbarment. That's what I would say. It's a misreading, misunderstanding by my client of the terms of that agreement. So in his mind, in his law partner's mind, once he had done 16 hours worth of work, they're thinking, because the transfer, the record supports the transfer done by Ms. Matthews, but be that as it may, the fact of the matter is that at that point, Mr. Jocelyn was not entitled to a refund. So they were not holding his money. Now, was it then intentional misappropriation, which result in automatic disbarment? There's some suggestion that intentional misappropriation is almost a per se offense in the District of Columbia. We think this conduct is not, repeat, not intentional misappropriation. It's a misreading.
What's the record evidence that he did the 16 hours of work? I think he said it's 17.
Right. He said he did quite a bit of work, because what happens in these Doha cases is that it's basically a review of a security application. So what we're required to do is read the I think it's called ESP, the electronic security, whatever. Read the document. And so what he's done a lot of these cases, you have to read the record, understand the record, understand why the Department of Defense is choosing to deny security claims. So it's really not a hearing where
So he had time entries, diary entries that he submitted that showed that work.
He did not keep timesheets. Did not keep timesheets. That's what the record supports. But he was able to testify as Mr. Jocelyn.
Was there any notes that he took of his review that he was able to submit?
They were not submitted. What was submitted was Mr. Jocelyn, his client, said that there were at least, I think, 8 phone calls, many emails back and forth, text messages, and a lot of contact between my client, Mr. Owens, and his client, Mr. Jocelyn, but I can't tell you that any timesheets were kept, because they were not. They were not.
Wasn't the basis for respondent's client from terminating him the fact that the client didn't feel like your client had been actually doing any work on the case?
Well, I think the breakdown really was more in communication. There was an issue.
But what was the cited justification by respondent's client as to why he was terminating him and why he hired another lawyer?
I think it was primarily lack of communication.
And not the fact that he didn't feel like working on the case?
I think that was a subsidiary issue, but I think the issue was that Mr. Jocelyn wanted a continuance of the September hearing date that was there. He wanted to continue to that, and the issue was with the disciplinary council meeting, with not disciplinary council, excuse me, with the Doha hearing. With the administrative law judge set a new date in. There was a little bit of a delay getting that information from Mr. Jocelyn, but the fact of the matter is that hearing was ultimately continued. That delay, if you will, and communication between my client and Mr. Jocelyn in terms of that continuance to that September date, I think caused Mr. Jocelyn at that point to have a little loss of faith in the client. Now, the ad hoc hearing committee, I must point out, found that Mr. Jocelyn was a very difficult and demanding client. Almost, I don't think it was daily phone calls, but numerous phone calls, numerous emails, wanted to insert himself in this process. My client, experienced litigator in this matter, clearly felt that he had the matter under control, and was prepared to try this case, knew this area of law. This is not his first appearance, and he does these all the time.
Mr. Brennan, I'm sorry to interrupt your answer, but in the interest of time, are we correct? Can you point us to anything in the record other than Mr. Owens' testimony that he worked 16 or 17 hours? So you're agreeing there's no time cards, there's no notes, there's no calendar entries, nothing that documents the amount of time that he had spent between February when this retainer agreement was signed and May when the funds were withdrawn, the entire $4,000 payment was withdrawn.
Right. I agree. There were no timesheets, guys. I agree with you on that. Mr. Jocelyn at the hearing testified that yes, he had a lot of contact with Mr. Owens. That there were, I believe it was 8 phone calls, I believe, a lot of emails going back and forth. And there's talk about when this case is going to be tried in May, because originally it was going to be tried in May, it would be tried in Mr. Jocelyn Liz, which is up in Rochester, New York. So clearly Mr. Owens was ready to go in May. It didn't go in May. It was then scheduled for September. So in terms of was Mr. Owens prepared? Did he know the material? He testified that he did know the material. He does this work all the time. He was familiar with the record in this case. And what's important is, the ad hoc hearing committee, the ad hoc hearing committee.
Excuse me, counsel. May I interrupt you? 1 moment.
I'm sorry.
Right, yeah, actually, sorry. Regarding your initial statement that it wasn't an intentional misappropriation,
Yes, I'm sorry. Yes.
So you're basically saying that we had good faith belief, then he's able to take those funds at the time he did.
That's correct, because the client would not be entitled to a refund.
Okay, so
And I would be defaulted,
what
but it,
evidence is there that he had the alleged misappropriation was objectively reasonable?
well, it was objective reason because he had done the work. He knew he had done the work and he was ready for the hearing in May when the hearing did not occur. And so he was prepared to do this case. He was ready to go forward. And I point out that the ad hoc hearing committee made a finding of fact. I mean, if I didn't mention this, they made a finding of fact that said the disciplinary council failed to prove by clear and convincing evidence that the entirety of the refund requested by Mr. Jocelyn was unearned. That was a finding of fact made by the ad hoc hearing committee. They then made a conclusion of law, which is even more persuasive. It says, I discussed in the hearing committee's finding of fact, disciplinary council has failed to prove by clear and convincing evidence that the fee was unearned. And they go on to say, conclusion of law, D, on page 91 of the ad hoc hearing committee says, disciplinary council failed to prove by clear and convincing evidence that those fees are unearned to a large part of the difficulty disciplinary council encountered in the absence of billing records. So there was not, repeat, not finding of fact below at the ad hoc hearing committee and saying that disciplinary council basically failed to prove by clear and convincing evidence that the fees were unearned. So what council
What's there in the record that indicates that your client's client provided informed consent to the kind of fee arrangement that or the taking of fees that your client undertook? Is there anything in the agreement? Is there anything in correspondence with his client that indicates that Mr. Josephson knew what was going on or provided informed consent to this ad hoc kind of arrangement?
The only thing I can tell you is that Mr. Jocelyn was the one that suggested this, I'll use the phrase kick-out clause. Mr. That was not in the original retainer agreement sent to Mr. Jocelyn. He's the one that inserted that. I think the inference can be is that Mr. Jocelyn inserted that. His request, that language was put in it. Jocelyn requested it. At that point in time, I would suggest that that's Mr. Jocelyn saying, I know that there's a discharge if the engagement is not completed. I'm only going to get that money that's unearned. His request, not my client's request.
So regardless of who inserted that language or not, and regardless of whether or not that language even exists in the retainer agreement, is it your contention that your client was permitted to withdraw the funds when he did?
Yeah, I would say that it was not intentional misappropriation.
I'm not asking about intentional misappropriation. I'm asking you whether or not your client was authorized at the point that he took out the money, whether or not he felt he was authorized to withdraw those
He
funds.
felt it was authorized because at that point, Mr. Jocelyn was not getting a refund. My client was still responsible for completing the engagement for which he was retained. But at that point, when the 16 hours had hit, no matter come H or high water, Mr. Jocelyn was not entitled to a refund of money.
So what level of misappropriation was it?
I'm sorry?
What level of misappropriation was it if it wasn't intentional
I think
misappropriation?
it would be a negligent misappropriation. And that's why I think that under Maryland law, that's why it should be sent to Maryland. So I think under Maryland law, we're finding negligent misappropriation in Maryland law.
And what's the connection to Maryland other than the fact that your client's office is located in there?
It's a Maryland retainer agreement. The also accounts are in Maryland, and the testimony in this case, which our disciplinary counsel says that my client made certain misstatements. That occurred in the District Court of Howard County and the Circuit Court of Howard County. So the testimony in court was in Maryland, Howard County. The IOLTA account was in Howard County. The retainer agreement was in Howard County. And nothing occurred in the District of Columbia, Maryland case.
So, but Mr. Brennan, let's proceed as if we're going to subject him to the rules.
I would say.
So with the District of Columbia's precedent, are you saying that what your client did was negligent misappropriation at worst?
Yeah, so I would look at the Crane case. We've cited it in our papers. And Crane was really interesting because Mr. Crane was found guilt or responsible, guilt or whatever, of making a certain misstatements to court, to the office court on 2 occasions, and taking funds from an estate to which he was not entitled. And the Court of Appeals imposed an 18-month suspension in that case. Based on Mr. Crane's conduct, I'm sort of intimately familiar with that case because I represent Mr. Crane on the Maryland end of that. So the answer is the Crane case, we cited that in our papers, and that he clearly took funds from an estate, or there had been a trust, I think it was a trust, I don't misspeak, took funds from a trust to which he was not entitled, and later on the court found that he lied about that, he had timesheets that were not contemporaneous, that had to be reconstructed. So Crane is a really good read for you all, quite frankly. Crane resulted in an 18-month suspension. I rely heavily on Crane for both the intent piece of it. There's also a discussion in Crane about whether or not withdrawal is a per se offense, or whether or not there's some culpable intent required. That language is in Crane as well.
And so just so I want to restate it, make sure I understand your argument. You're saying that at the time that Mr. Owens withdrew the $4,000 in May, he was ready to go to hearing at the earlier hearing date.
That's correct.
And in his mind, he presumed that he had spent 16 hours to prepare for it and was therefore entitled to pay himself the money.
That is absolutely our position, yes.
And that May timeframe is tied to the date that that hearing was originally supposed to take place. Is that May timeframe when he withdrew the funds tied to the original date of the hearing?
That's correct. The original date of the hearing was in May.
That's when they called you. That's when we want you to I said yes.
They wanted to advance it from that date, so that was at the time.
What's that?
Folks involved.
Sure.
That's when council called me and asked if we could try it. If I was ready to proceed now, I said yes, and they could advance it and do it.
I slightly misspoke. Counsel for the government in the Doha reached out to Mr. Owens and said, can we advance the date and try the case in New York? Mr. Owens said, yes, I'm ready to go. We can advance the date, put it in and try it in New York. And it ultimately did not happen. So I misspoke if I suggested there was a firm date, there was not. But opposing counsel in the Doha reached out to him and said, can we go in May? And Mr. Owens said, yes, we can. I'm ready to go. So that's the correct record.
Counsel, you're putting a lot on your client's testimony that he spent 16 hours or more. But didn't the hearing committee reject that testimony by him? Don't we have a credibility finding by the hearing committee that that story was or that account by your client was a fabulation? And if so, how would we get beyond that credibility determination by the hearing committee? Well, it seems to run counter to the record that we may be that is before us.
So I have two responses to that. One is that I think the ad committee relied very heavily on the transcripts from the District Court of Howard County and the Circuit Court of Howard County. And by Mr. Owens' clear admission, he did not present effectively or perhaps at all the time that he had spent on the case before either the District Court of Howard County or the Circuit Court of Howard County. That's number one. Number two, I think that you do not have to accept necessarily the findings of fact on credibility, because the other interesting part about the Crane decision is it talks about ultimate facts, and our ultimate facts, the functional equivalent, can this board or indeed the court, more importantly, I think this board can reject the findings if it goes to an ultimate fact, which they say the
But that may go to the level of intent, whether it's intentional or reckless. But does it go to the underlying question and finding as to whether your client's testimony on the issue was credible or not? Those are two separate. One is a question of fact. One is a question of mixed law and fact.
Right, mixed law. I think mixed law and fact under Crane. I think this board can make an independent determination on that issue.
But the credibility finding is not a mixed question of law and fact. And when the hearing committee says it was a fabulation and they rejected his testimony on that, how is that a mixed question? How is that a question of law to any extent?
Well, I think the hearing committee, there's not substantial evidence in the record for that. And what the hearing committee did is they tried to rely solely on the poor record that was made in the district court in Howard County and the circuit court in Howard County. By my own admission, when the case was presented in Howard County, the district court and the circuit court, there was not a good record made in terms of the amount of time that Mr. Crane had spent. So the hearing committee, I think, relied too much on that record, basically the absence of that. And so that's why I don't think that there's substantial basis in the record for the hearing committee to make that finding, and that can be rejected by this board.
Did your client have an opportunity in this disciplinary proceeding to supplement those that Howard County in those prior proceedings, producing documents to disciplinary counsel and introducing them at the hearing committee's hearing?
Well, at the hearing committee, he testified under oath as to what he had done.
I understand the testimony, but he had an opportunity, as counsel, to submit whatever documentation he had in response to this investigation.
At the hearing committee.
Yes.
Yeah, the record is what it is.
And do you believe or understand that he had some burden of production on this issue?
Well, I think that the burden is on disciplinary counsel, because as I pointed out a few minutes ago, the ad hoc hearing committee found that disciplinary counsel had not met its burden by clear and convincing evidence to show that the fees were unearned. They made both a finding of fact on that issue as well as a conclusion of law. And I think it's on page 91 that I just read. They say that disciplinary counsel did not meet its burden by clear and convincing evidence to show that the fees are unearned under rule 1.16. They made that finding, and I think
They did, and that's why I'm asking you this question. Do you understand that your client had some burden of production on that issue? Or is it your position he had no burden whatsoever?
I think the burden, and in disciplinary hearing, the burden was on disciplinary counsel.
Yeah, the ultimate burden of proof. I'm asking about the burden of production. Your client is the one who raised the issue that we had 17 hours of work on this, and that therefore the funds he took were earned. And I'm asking you, sir, do you understand that your client has any burden of production on that issue?
But he testified, and we relied on the testimony of the complainant, in this case, Mr. Josselson, who talked about the number of emails, about the number of phone calls he had. So we combined the two. We combined my client's testimony along with Mr. Josselson's testimony about the amount of contact they had, the emails and so forth. And I think that was very clear testimony, and I think it was bears repeating. My client was prepared, as I indicated earlier, when counsel in the Doha hearing asked him to be advanced, he said he was ready to go. And I think that's good, compelling evidence that he was ready to try this case, because it's not the kind of litigation where you necessarily generate pleadings or motions or things like that. It's reviewing a record and making arguments that security clearance should be granted.
Counsel, how do you reconcile the holding in Mance with the statement or the sentence in the fee agreement that says the firm has the obligation to complete the engagement absent good cause for withdrawal once the fee is paid? So I'm focusing, of course, on complete the engagement.
Right.
So I'm going to with the requirement.
I printed out 4 quotes from the inside, in preparation for argument.
Sure.
But
I would throw the question. No,
I think the key is the language I reason I focus on Mance is that it says the respondent was obligated to return the initial payment or the portion that he had not earned, because the lawyer cannot earn a fee for doing nothing. And then later on it says a corollary to the rule of flat fees in advance of unearned fees, the fee must be held as client funds in a trust account.
How does this?
Until they are earned. So Mance throughout says until they are earned.
But Mance also says extreme front loading of payment milestones will not excuse a lawyer from safekeeping the client's funds until it can reasonably said that they have been earned in light of the scope of the representation.
Wow.
So scope of representation, then you look at the sentence that I just read to you from the agreement. So I'm asking, how do you compare those two and say that he's complied with Mance?
Well, so I think he's complied with Mance because the front loading was always very interesting. Figured for criminal defense lawyers and sole practitioners on the front loading is that you charge, say, $25,000 for a murder case, you put the money in your IOLTA account, and then you say, oh, gee, I entered my appearance, I looked at discovery, I earned 20 grand. That's what they mean by front loading, that there's unreasonable acceleration of the drawdown. But here, what the testimony is, there is not an unreasonable acceleration of the drawdown. As we discussed earlier, Mr. Owens was prepared at the Doe House Council request to try this case in May. He wanted to advance it. So it was not a front loading situation. It was a case where he had in fact done the work. All we needed to do is have that hearing, but is prepared to do it because once having read the record, you could make the argument in front of the Doe House. So I think Nance talks about the unreasonable front loading. Represent a lot of lawyers on the unreasonable front loading, that there's, loaded up on the front end. That's not what happened here. My client was ready to go, and Nance talks about unearned fees, talks about front loading. That's not what happened here. My client was ready to request it to advance the state, set it in for May. He was prepared to do that. He'd done the work, and the fees in his judgment were earned. And most importantly, and this is where the issue of intent comes from. At that point, he knew, based on the language of Mr. Jocelyn himself, that placed in the agreement, Mr. Jocelyn was not going to get it. I think I've gone right to my rebuttal.
No, you still have your 5 minutes.
Okay, thank you. Anything else before I sit down on that one? Thank you.
May it please the board, Jack Metzler for the Office of Disciplinary Counsel. I'd like to just start by correcting one thing we heard about the Crane case. The Crane case is very clear about the hearing committee's credibility findings and when they should be upheld and by the board and by the court, and when they can be adjusted. And what Crane says is that if they are supported by substantial evidence and they are not contrary to law, the board and the court are bound by those credibility hearings, by those credibility findings. What the hearing committee found here is it found a lot of lying on Mr. Owens' behalf.
Mr. Mester, did the hearing committee find that he lied about the 16 hours or the 17 hours?
So it found that his testimony that he testified in this proceeding, consistent with what you just heard from my friend, that that he didn't have the opportunity to talk about 16 hours in the Maryland case, and the hearing committee found that was a lie and was shocked. I think if you look at the last couple of pages of the hearing committee report, it says essentially, I don't know what he expected. Did he think we were even going to look at these transcripts? We did. There was a lot of talk about the hours in the Maryland, and so when he told us that he didn't have the opportunity, that my lawyer said didn't ask me any questions about that, I didn't present the evidence, that was a lie and it was deliberately false. That's what the hearing committee said. They also said that his testimony about the 16 hours was not credible. It didn't go so far as to say it was deliberately dishonest. But it said that testimony was not credible, and it compared again what he said at this hearing with what he did testify about in the Maryland hearing. In the Maryland hearing, he said with regard to these certain meetings and things he brought up for the hearing committee. In Maryland, he said, no, that really, I wasn't working on a case then. I wouldn't bill for that. And he said the opposite.
But Mr. Mussel, didn't they also say that you did not meet your burden of proof to show that all 4,000 was unearned?
They did say that. And I'm glad you asked, because there's an important question. There's an important difference between that question and the question that's at stake in the misappropriation. So if you'll permit me to back up just a moment to that.
Well, let me ask you this. What is ODC's position that all 4,000 is unearned?
So the question is when, right? So at the point of when Mr. Owens took money out and paid off his credit card bill, he took all of the entire fee, $4,000. That's what he used to pay his credit card bill. The fee, as we've been discussing, encompassed the entire organization, including representing Mr. Josephson at the security hearing, security clearance hearing. And there's no dispute that didn't happen. So there's things that he promised to do that he didn't do. And so he couldn't have earned the entire fee because he didn't do everything that he promise. Now, that's a different situation from at the end in the fee agreement, and actually with regard to rule 1.16, because the fee agreement does say that if the representation is terminated, then we have this provision about how much refund Mr. Josephson was due back, and that depends on how many hours he worked. So at the point of the misappropriation, the hours really don't matter. All that matters is that it was less than everything. Whereas at the end, it does matter because that provision about calculating the refund comes into play. And so we would have had to show that, our task was, and the hearing committee is unclear about the timing, because Mr. Josephson or Mr. Owens did refund after a couple of months $2,000. And what Mr. Josephson went after in Maryland was the rest of the $2,000, and he got $1,750 of it, not the entire thing. So it's unclear what the hearing committee had in mind when it said we didn't show that all of the refund that Mr. Josephson requested was unearned. Maybe it meant that 1 hour. I don't know. Maybe it meant $2,000 we hadn't got back yet.
Let's just bear with me with this hypothetical for a second, although it's not really hypothetical, but you didn't meet your burden of showing that he didn't work 16 hours of the case at the time that he withdrew the funds, right? Just say yes, please, just so I can.
I'll say yes.
Okay, thank you. So why is it unreasonable for respondent at the time that this document is signed for him to say to himself, okay, I know that $250 an hour means 16 hours of work, 14,000. As soon as I do 16 hours of work, this is pretty much my money, right? And at the time he withdraws the funds, he says, okay, I know I've done at least 16 hours of work. Maybe I don't have the best records, even though I'm obligated to keep records. And I haven't informed my client of that, but I've now worked 16 hours. So now I've withdrawn these funds, knowing that I've done at least 16 hours of work. So if I were to get terminated tomorrow, I'd be able to keep all this money because I know I've done 16 hours of work on this. Why isn't that negligent misappropriation as opposed to intentional misappropriation?
Right. So, in the Gray case, the standard for negligent misappropriation is whether that relief, though incorrect, was nevertheless reasonable. And I would say it's not reasonable for two reasons. Well, three reasons. One of which is that I take it they concede this now, but the agreement itself didn't justify, it didn't say he could earn the money at $250 an hour. That only came into play if the agreement was terminated, the trigger, as you say, which hadn't happened. He knew it hadn't happened. But I take your question, Steve. What about the practical question? He's like, if I finish this, if he fires me, it doesn't matter. He's not getting the money back anyway. I can keep it. And my answer is that's just not how it works. If an attorney is in some other kind of case, a probate case, says, look, I have here ready on my desk my fee petition is for $2,000, and this judge has never denied one of these ever, and it is well documented. I know this is going to be granted. I'm going to file it tomorrow. And this judge is very quick. He's going to file it. He's going to grant it tomorrow. That's what always happens. So I'm going to take the money out today. That's not an authorized use. If he waits till the next day, yes, that's an authorized use, no misappropriation. But if he says, I'm going to take a loan today, knowing that in the end, I'm going to get this money, that is a misappropriation. There's plenty of cases that will say that. And then the third reason is just as a matter of fact. He was this idea that he believed he had earned the money has to be taken into context of the hearing committee's findings about his credibility. They found that he was lying all along. So why would you say, it's technically possible he could have believed that when the hearing committee heard this testimony? I
guess I don't want to get too far through it because I really want to understand what takes this out. If we have to agree because you didn't meet your burden that he had worked at least 16 hours on the matter at the time that he withdrew the funds, right? And if he would have been fired that day, he would have been able to make the argument supposedly to the client, I've now earned this entire fee because I've worked 16 hours on this case, right? We have to accept that at this point.
No, I disagree. I know you made me say yes earlier.
Okay, it's not binding on you. But my point is, I just want to understand how does this take us from negligent to intentional? That's all I want to know.
Sure, so the way that the court looks at negligent versus intentional is the first question is you look at how the attorney used the money. And this distinguishes things, circumstances like an attorney wrote a check off of his trust account for an expense that was slightly more than it was supposed to be, or he failed to calculate another withdrawal, and so a second client's money got invaded by a check for the first client, right? So how is he using the money is one factor. And in this case, we know, and so that's, and you might say in that case, that was, you know, accidental, it was inadvertent, he didn't mean to invade the second client's money, things like that. In this case, we don't have that. We know he was taking out Mr. Josephson's money. We know he spent it the next day for his own personal expense. So this wasn't that kind of inadvertence. So then the next question is, you know, well, then why did he take it out? And his answer is, I thought I could take it because I earned it. And I take it they now agree that he didn't earn it, but at least I reasonably thought that I earned it. And so there are two answers to that. Number one is the agreement doesn't say that. There's no reasonable reading of the agreement that says that. The second answer is that Mr. Owens claimed that he believed it. That wasn't true. This is another, you haven't gotten to this yet, but that was another finding that the hearing committee made. He didn't, it's not only that he didn't reasonably believe he could take the money, he didn't believe it at all. His understanding of the agreement was the same as Mr. Josephson's. And he even said in this proceeding that if it was a flat fee, which it obviously was, and he seems to admit it now, that he would have been able to take that money at that time.
And you're saying that the hearing committee made a finding that respondent and his client had the same understanding of the agreement.
That's correct. And they also made the finding that that Mr. Owens admitted in this, I think this is finding 63. He admitted in this proceeding that if it was a flat fee agreement, and by the way, he admitted it was a flat fee agreement in his answer to the charges. And then he testified, well, if that was so, I wasn't allowed to take the money. So he didn't even believe he was allowed to take the money. Now, maybe he thought, I'm not going to get caught, and I anticipate that I'm going to finish the engagement. I anticipate that if he fires me, I'll be able to make an argument about the hours. But he didn't actually think he had worked the hours, and he didn't actually think he was entitled to take it because he worked the hours. There's a finding about that, and that one, again, falls under Crane. It is supported by substantial evidence in the records. And you can see it because that testimony, again, was all over Maryland. When misappropriation wasn't on the table, Mr. Owens was, very adamant. He said, this is a flat fee agreement. I don't do hourly agreements. I don't know how to do hourly billing. I wouldn't have taken this if there was an hourly billing case. Then he comes to the hearing committee and said, no. This thing that Mr. Josephson put in means I can take the fee and I can earn it at $250 an hour. The hearing committee said, that's false. It was intentionally deliberately false testimony before the hearing committee.
Mr. Messer, I'm genuinely gotten myself confused about how disciplinary counsel's burden works in a case like this, and whether there's, I understand you have the burden of persuasion on the ultimate issue about whether the fee was unearned. But when you bring a case like this and assert that there was misappropriation and an early withdrawal of trusted funds, and the respondent comes forward and says, no, I worked 17 hours. And I'm not sure how we're going to reconcile the hearing committee report, which finds that testimony was not credible. And then they ultimately find that disciplinary counsel somehow failed to meet its burden to prove the negative. Sure. And so, can you help us? How do we navigate through that?
Yes, well, I think the answer is to look at the burden of proof in terms of the violations that were at issue. So there are two different violations, and one of them is misappropriation. The other is the 1.16, failure to return an unearned fee. And it is only the second one where the hearing committee found we had established that. Now, there are some cases. And we had one in Mr. Alexie's case a while back, where there's a question about whether there was enough work, whether the amount that the attorney took had been earned because he had worked enough to take it out. That question doesn't happen here because the fee agreement is very clear. It says when Mr. Josephson pays the money, Mr. Owens has to complete the representation, and we know there are things that were part of the representation that didn't happen. Mr. Owens didn't prepare Mr. Josephson for the hearing. He didn't actually represent him at the hearing. Those are services that were included. He had to do something to earn those, earn at least part of whatever, you can divide it out. Maybe 99% of it is everything up to the day of the hearing, and 1% is the hearing. It doesn't matter. He didn't do that 1%. I would, that's for illustration, but we know that he didn't do all of the services that he promised, but he did take all of the money. So when he paid off his credit card bill, he was using money that at least part of it he didn't earn. And so that's how I think you reconcile it.
Because that's the key though. It's at least part of it that he didn't earn. And you didn't prove which part of it he didn't earn.
Well, the definition is, so like whatever the part was, it was an unauthorized use of entrusted funds. Now, like the regular interpretation, now again, we're talking about the difference between, we have a dispute, I think, the board and we'll find out what the Court of Appeal says in the election. We had a disagreement about sort of the interim question. Can you take part of it in the middle? But I don't think there is any reasonable dispute about a case like this, where we're talking about the entire amount of the fee, and the work is unquestionably no dispute that the entirety of the work was not done. He was taking money for services that he hadn't performed. And just going to, there's no choice of law question about that either. The law in DC, Maryland, Virginia, and everywhere else that I know of is that an attorney is not allowed to take unearned fees and spend them on his credit card without the client's informed consent. And there's no allegation that the client gave informed consent to this kind of arrangement here. So
the hearing committee did not find, am I right about this? They did not explicitly find that respondent was lying about the 16 hours worked.
they said his testimony on that was
Not credible.
But they also said that, I mean, they took the same interpretation that I'm presenting today, which is that that didn't matter for the misappropriation. It matters for whether we can show that he didn't return all of the unearned fee. And remember, he did refund $2,000 and then he did $2,000 of the fee. So arguably, the question there was not whether we could show that we could show that he hadn't worked at least 8 to keep that, and then I guess another 8 to refund the remaining amount.
So right now, there is some space that respondent could have taken that $4,000 in May, and maybe he earned 3,000 of it, or maybe he earned 2,000 of it.
I think that would be not inconsistent with the findings that we have here. But the fact is that we took all of it, and we don't say, well, it's feeling if you take twice as much, or 75 or 25% of the amount. That's not how the misappropriation will work. You're not allowed to take any of the money.
Could this board say that the fact that we don't know how much he actually may have earned, could that mitigate against a finding of intentional misappropriation?
So again, the difference between intentional misappropriation and negligent.
How about and include reckless too in your?
Okay, so I always find reckless kind of hard to apply in some of these circumstances, because it's whether you recognize that.
But it's an all or nothing thing with you, right? You can't take a part of the flat fee. It's all or nothing. No, I'm just kidding. Go ahead.
Well, it's not okay. But so the first question is, intention. Did they treat the money as their own? That's what the Anderson case is. That's what he did. There's an excuse for that, right? It could be negligent even if he did it on purpose. And we don't, the court is clear about this. you don't look to, when you're looking for intentional misappropriation, the question is not, did he intend to steal from the client? The question is, you know, did he take the money and treat it as his own, like not inadvertently, did it on purpose? And that's what happened here. Now you can get out of that. It might be negligent, even if it would otherwise look like intentional. If you did it with a basis, with an incorrect understanding of the law or incorrect understanding of the facts that was reasonable under the circumstance, that's the gray circle. That's the gray case. And here, I think looking at whether it was reasonable as a matter of law, all you have to do is look at the fee agreement. Fee agreement is pretty clear. This $250 an hour didn't come into play until unless there was a termination that hadn't happened. There's no reasonable way for him to read the agreement as he claims to read it below. That he could just earn at $250 an hour.
But how about if I responded and I think, you know, government counsel has asked you, could I go in May? And I know I can go in May. And I know it takes me 16, 17 hours to get ready for these hearings. I know I've done the work to be ready. I can go in May. And then I think, respondent, I can take this $4,000. I can pay myself this $4,000 legitimately because I worked the hours for it. If Mr. Josselson comes back and asks for a refund, if he fires me and asks for a refund, I can make the proof that I've earned at $250 an hour, the amount that would end up to be this $4,000. So I wouldn't owe him a refund. So I could pay myself. So can that fall into recklessness?
I think you probably could make that argument. So the way that you would say that would be that it was a reckless misappropriation because he could see the risk that those things that he thought were going to happen wouldn't happen. That there would be a termination and he wouldn't be able to show the hours that he had worked. And as it turned out, in fact, he wasn't able to show the hours. So, you know, if he knew this, he knew he didn't know how to do hourly billing. He knew that he didn't keep any hourly records. So the idea that, you know, he thought, I'm going to be able to prove this later, that's very suspect. And if that's what he was trying to rely on, you could describe that, I think, as a reckless misappropriation. In that he would have to have recognized the risk that these things didn't happen, and he went ahead anyway and took the money. But then as to negligent, again, just to return to the thought I had before, I don't think there's a reasonable understanding of the law that he was operating under, and that sort of goes to the facts as well, because if you go to the and by the way, if it were negligent, that would also be an excuse for I think that would overcome recklessness as well. But I don't think it does, because the agreement was clear. And as a matter of fact, he knew he wasn't going to be able to prove that there was 16 hours for all the reasons that I just discussed. And in fact, as a hearing was being held, he didn't actually believe that he had that he could earn the amount of money that he took under the terms of the agreement. So for all of those reasons, I think finding a reckless or intentional misappropriation is appropriate.
Okay, thank you. Anyone else have any questions? Mr. Tiger, any questions? Thank you.
No further questions. We actually got the hearings and credibility findings of the hearing committee and recommend that there be a disbarment.
Thank you.
Thank you. So as a procedural matter, it said we, as responded, we took exception to the findings of fact and conclusions of law in this case. But disciplinary counsel did not take exceptions to any findings of fact or conclusions of law. And the reason I mention that is that the findings of fact, as I mentioned earlier, is that in the conclusion of law, paragraph 148 said that disciplinary counsel has failed to prove by clear and convincing evidence that the entirety of the refund requested by Mr. Johnson was unearned by respondent. And then on paragraph 150 says, the hearing committee concludes that disciplinary counsel has failed to prove by clear and convincing evidence that the fee respondent failed to return one request was unearned. They have not taken exceptions to that finding of fact or conclusion of law by the ad hoc hearing committee. They have not done that. So that's what we are saying. And so I think some of the colloquy that was been exchanged earlier, we know that Mr. Owens is ready to go in May. And indeed, the testimony for the ad hoc hearing committee, Mr. Jocelyn himself said that he, and this is evidence put in by disciplinary counsel, he talked about at least eight phone calls with my client prior to the May date. Emails with opposing counsel, discussions with opposing counsel. It is clear.
If there had been, I have to keep my finger on it sometimes.
I'm sorry.
If there had been no kick-out agreement, and if somehow the relationship had ended, for instance, your client got sick, and as you have told us, he was ready to go, he'd done whatever he did. How would you, in that hypothetical situation, calculate how much of the fee had been earned?
So I guess in the absence of a kick-out clause, I think you would then get into the issue of what's an appropriate hourly rate for work that had been performed but yet to be done. And I think it creates a problem that frankly we don't have here because Jocelyn put in the kick-out clause.
Well, that's what I thought. You asked work yet to be done. Doesn't the man's court say that however you calculate the amount that the client must have get back must be enough to permit the client to retain other counsel to do the rest of the work. So the fact that, one is ready, not trying to allow cases, I go ahead and work, that's ready, I say I'm ready. And then they don't say, okay, well, we're ready, I know. You're very much too late.
We've all done there.
Yeah. So, how would you calculate?
So again, I reread Nance, and so you're absolutely right. Nance talked about, well, you got to get the money back so that the client can hire new counsel to take care of things.
I don't know.
100% correct about that. And so what Nance focused on is the unearned portion of that. So I think the total fee in Nance, if I remember correct, I think it was $15,000. He paid $7,500. He'd done some preliminary work about having the person's son turned in, et cetera, et cetera. Nothing had gone down.
If you, they come to the party of the way because you're that's it. How, on what basis would you calculate the amount of money that was due back to Mr. Gross?
I think it would be difficult, but you could do the following. You could say that my client had reviewed the case, had understood the record in this case, and spoke to opposing counsel in the Doha matter, had spoken to his counsel. I mean, it's almost a functional equivalent. I mean, if you're in a family law matter, say it's an hourly matter, you can sort of change the hypothetical if I may for a moment. If you're in a family law matter and you've done all the work, spent an hourly, you clearly earned it, then you get sick and you can't complete the representation, or have the counsel dies and you've done all this work that you've earned on an hourly basis on a family law matter, lawyer dies, well, they would have to hire new counsel, and some of that work may have to be redone. So I think that merely because, so I think in this case, it's clear, it is clear that my client, Mr. Owens, did a lot of work in preparing this Jocelyn matter.
What percentage of the total amount that would be involved to try the case to a conclusion are you suggesting has been done? Because the Doha rules are quite clear. It's to be called, there's a difference to be known, there's counsel arguments to be made, and it's called the defense officer during the field, there's a prospect of an appeal as well. So is there substantial work that can be done?
So,
at the point where you're trying to call on?
There's no question that there was work yet to be done when the money was withdrawn in May. I don't disagree with that at all. The representation needed to be completed. However, my client testified that he grossly underpriced this case, that he liked these kinds of cases. He charged only $4,000 for this matter. So in his mind, he had done that work. He had work yet to be done. No question about that. But he was ready to go in May. He had Mr. Josselson, by his own amendment to the agreement, was not entitled to a refund. That is not contrary to the fact that my client is still obligated to do the work under the terms of the agreement through the hearing. I don't disagree with that at all. He was obligated to do that, but also I can't emphasize enough, Mr. Josselson was not entitled to a refund because my client had done the work. And so I think we can reconcile. I think you can reconcile this. To my client as a lawyer had an obligation, ethically and morally, to complete the representation. He does not deny that.
Counsel, to the point you opened your rebuttal argument, citing finding of fact 150, and you may have quoted from 148, but at the end of that finding, it kind of refines what is said at 150, or perhaps 150 that explains it somewhat differently. I'm not sure.
Meaning the presence of the word entirety?
Entirely.
Yeah. Not lost in the eyes.
Disciplinary counsel has failed to prove by clear and convincing evidence that the entirety of the question was an argument. I would also call your attention to finding of fact 28. The hearing committee finds that disciplinary counsel has proved by clear and convincing evidence that a significant portion of the $4,000 flat fee paid by Mr. Josselson remained unearned by respondent at the time the full fee was withdrawn. Now, these are two separate things. Full fee was withdrawn from the IOTA account on May 18, 2017. So I think finding of fact 28 is at odds with the perhaps the point you're trying to make by citing 150.
It is, except I think when they do the conclusion of law at the end, I think they make clear on page 91 that disciplinary counsel failed to prove by clear and convincing evidence that those fees are unearned. Now it said due in large part to the difficulty absence billing records, but they basically say that look at disciplinary counsel could not prove by clear and convincing evidence what portion, if any, of these fees are unearned. Now they use the word entirety in one finding, they don't use it in the other.
And they use the phrase significant portion was unearned. It's not enough to get us to misappropriation.
No, I don't think it's enough to get you to misappropriation, because I think that the record is that my client testified he had done this work. And evidence put on by disciplinary counsel from Mr. Josselson himself, was Mr. Josselson himself, and before the May date, had a lot of contact with my client. And so basically what I am saying to this board is that disciplinary counsel did not meet their burden of showing that the fees were unearned at the time of the withdrawal. And the record, Mr. Owens testified that he had done at least 17 hours, that he had done this work, that Mr. Josselson himself testified in numerous phone calls that he had with my client. There was a review with Doha counsel. There was work done in this case. And that gets us back to, was there a good faithless belief by my client at the time the funds were withdrawn that Mr. Josselson, when the day is done, would not be entitled to a refund? And I keep coming back to that Mr. Josselson would not be entitled to a refund. My client, and I don't think these two facts are irreconcilable. I think because what happens is Mr. Owens would still be obligated to complete the representation, but Mr. Josselson himself would not be entitled to a refund based on language he himself inserted into this agreement. So, and I do just emphasize that the credibility issues were more basically to the issue of, had he, there's no finding that my client lied. There's no finding by the ad hoc hearing commission my client lied about the number of hours that were worked. But the way that came out was that the ad hoc hearing committee found that my client should have had an opportunity to explain to the district court and the circuit court in Howard County the amount of hours that he worked. He failed to do so, but the ad hoc hearing committee never made a finding that my client lied about the 17 hours of working. That finding was not repeated, not in the record.
Thank you, counsel. Okay, case is submitted. Thank you.
Thank you.